Hello again, I'm attorney Robert Flessis for Robbins & Lloyd Career Training Institute. This is part 3 of course 6, and we're discussing case law updates. Now, as I said in previous course 6 videos, there isn't enough new case law to discuss. So I'm going to talk about the structure of courts and how they work, and I bet many people don't know this. In course 5, we discuss legislative updates. This course discusses case law updates. What's the difference? Legislation and case law are two primary sources of law, but they differ in their origins, authority, and application. Here's an overview of the differences between legislation and case law. Legislation refers to laws that are created by legislative bodies, such as Congress at the federal level or state legislators. These bodies propose, debate, and pass bills that are then signed into law by the appropriate authority, for example, the president or the governor. Statutes and codes are examples of legislative enactments. Case law, also known as common law or judge-made law, evolves through judicial decisions in court cases. Judges interpret and apply existing laws to specific cases, and they establish legal principles and precedents. Case law builds on prior court decisions and provides guidance for future similar cases. Legislation can cover a wide range of legal topics and issues. It sets forth general rules, rights, obligations, and prohibitions that apply to society as a whole or specific sectors. Legislation is typically broad and applies to everyone within the jurisdiction unless specified otherwise. Case law, on the other hand, focuses on the interpretation and application of laws to specific factual scenarios. It provides guidance on how the law should be understood and applied in different circumstances. Case law is specific to the particular facts and parties involved in each case, but it can establish legal principles that have broader implications. Legislation is the primary source of law and holds higher authority than case law. It establishes legal rules that must be followed by individuals, organizations, and government entities. Courts generally defer to legislation when interpreting laws unless the constitutional issue or ambiguity arises. Case law is persuasive rather than binding. It helps in interpreting legislation, resolving legal disputes, and guiding future court decisions. While courts often consider precedents set by higher courts within the same jurisdiction, they're not strictly bound by previous decisions and can deviate from them under certain circumstances. Legislation can be modified, amended, or repealed by the legislative body that enacted it or through subsequent legislation. This allows lawmakers to adapt the law to changing circumstances, societal needs, or policy considerations. Case law can evolve over time as new cases are heard and decided. Courts may revisit and reinterpret previous decisions or establish new precedents that modify or clarify existing legal principles. This process helps shape and refine the law based on evolving societal norms and legal developments. In summary, legislation is created by legislative bodies and establishes general rules, while case law emerges from court decisions and provides interpretations and applications of laws to specific fact situations. Legislation carries higher authority and is binding on all, while case law offers persuasive guidance and can evolve over time. Case law presents the facts, then zeroes in on the issue that the case presents. Courts will apply the facts to the existing law, then render their decision, which is called their holding. Case law weaves through our court systems in Wisconsin. The first court that you bring your claim into is the circuit courts. These are courts that cover individual counties. In Wisconsin, we have 69 circuit courts, which are divided into 10 administrative districts. As noted by the Wisconsin Court System website, the circuit courts are trial courts overseeing both criminal and civil actions that include probate, juvenile, and traffic cases. They conduct jury trials. And as of 2023, there are 261 circuit court judges. The circuit courts are funded through state and county money to pay judges, official court reporters, and reserve judges who are retired judges that fill in when an elected judge is not available. The funding is also used to train judges. Counties also fund guardians ad litem, which are court-appointed attorneys, court-appointed witnesses, interpreters, and jurors. If you want to challenge the circuit court's decision, then you have to go where? To the Court of Appeals. If you disagree with the decision of the Court of Appeals, then your next petition would be to the Wisconsin Supreme Court. The difference between the lower courts and Supreme Court is that the Supreme Court doesn't have to hear your case. It's a discretionary court. The Wisconsin Court of Appeals has 4 districts. They employ staff attorneys and legal assistants. You can live stream Wisconsin Supreme Court and Court of Appeals hearings. Did you know that? Now, most people go to the circuit courts for things like divorce, criminal and traffic cases, probate, and juvenile matters. When you appear in court, you'll see the judge who is elevated on a bench, the court's clerk who schedules and answers the court's phone, among other things, the court reporter, and a bailiff, which is handled by the local county sheriff's department. Lawyers play an important part of the judicial systems. We're called officers of the court and are regulated by the Supreme Court of Wisconsin through the State Bar of Wisconsin. Now, attorneys have to follow Supreme Court rules, and there are a whole bunch of rules which lawyers are expected to know and abide by. Otherwise, you get sanctioned by the Supreme Court. Attorneys, just like realtors, must pay dues to continue to practice. Did you know that an attorney who doesn't pay their court-ordered child support or doesn't comply with a subpoena or warrant can have their license suspended for up to 5 years? Wow. There's another rule that applies to attorneys who are suspended, revoked, die, or can't be found anywhere. If no one's available to serve their clients, then the court can appoint an attorney to enter that attorney's office to protect client rights, files, and property. If a sole proprietor attorney has a medical incapacity, any interested person or licensed attorney can file a petition with the circuit court based upon that medical incapacity. Another attorney can then be appointed to operate on behalf of the incapacitated attorney. There's also a client protection fund that's established to reimburse for losses caused by the dishonest conduct of state bar members. Members of the State Bar fund this client protection fund each year with their dues. In real estate continuing education courses, we often discuss the unauthorized practice of law. Well, what is the definition of the practice of law? According to the Supreme Court rules, it's the application of legal principles and judgment where there's a client relationship of trust or reliance, which requires knowledge, judgment, and skill of a person trained as a lawyer. The practice of law includes giving advice of a client's legal rights, drafting legal documents or agreements, representation of an entity or person in a court, administrative proceedings, or other dispute resolution processes. In order to practice law, you have to be licensed by the Wisconsin Supreme Court and be a member of the State Bar of Wisconsin. If you're licensed to practice law in Wisconsin, you can stand out and represent yourself as an attorney at law, lawyer, solicitor, counselor, attorney, and counselor. Attorneys must complete continuing education just like you every 2 years. We have to attend a minimum of 30 hours of approved CLE. We also have to attend a minimum of 3 hours of legal ethics and professional responsibility. We can even carry over up to 15 approved credits to the next reporting period. Judges are required to take compulsory education by earning 60 credits each 6 years by participating in educational programs approved by the Judicial Education Committee. Well, that's it for part 3 of course 6. Next up is our review. I'll see you there.